matters to which the public deserve them.
Joanna Cherry.
Thank you, Mr Speaker. I'm very grateful to be called to speak in this debate. Can I start by just dealing with the frequent red herring we get from the benches opposite, that this debate is about impugning the government's responsibility to prepare for a no-deal Brexit. It's not about that. It's about their ability to make those preparations competently and without squandering taxpayers' money. Now, of course, the government have to prepare for no deal because they are insistent on keeping no deal on the table and voted against the SNP amendment to take it off the table last week. And as some honourable members opposite have very generously accepted, no deal could be taken off the table by a number of routes, including an extension or the option of revoking Article 50, the lifeline thrown to the British government by a number of Scottish politicians, including myself. And in that respect, I declare an interest with the backing of the Good Law project. So let's just get that red herring off the table. This isn't about preparing. This isn't about the opposition querying whether the government should prepare for a no-deal Brexit. This is about the opposition doing their job and holding to the government to account for carrying out those preparations in a shambolic, chaotic fashion, and a fashion that's wasteful of public money. Next point, Mr Speaker. What happened last week was that the government settled out of court litigation brought against them by Eurotunnel for the legal reasons just laid out by the Honourable Lady for Nottingham South. They paid over £33 million to buy off the risk of losing the action and having to pay more. And the action was brought because they had failed to put 3 contracts, not just seaborne freight, but so far as I'm aware, all 3 contracts out to competitive tender. So that £33 million was in lieu of a larger sum that would have had to have been paid out in damages if the court case had gone ahead and the government had lost. So that is why, Mr Speaker, I, as a lawyer, am so puzzled by the Secretary of State for Transports and the Secretary of State for Health's insistence that this £33 million will somehow pay for increased security at the ports. In my long experience, 30 years, 20-odd years at the bar and a number of years as a solicitor, I have never heard of such a stipulation in an out-of-court settlement in this type of a case. That is why I was so puzzled and perhaps expressed my puzzlement in terms that were unparliamentary. But I want to know, and I know the junior minister is looking at his phone and not interested in what the SNP have to say as usual, but this isn't going to go away, because I'm going to pursue it. I'm going to pursue it with Eurotunnel and others. I want to know, well, maybe he could just listen and be quiet while he's listening. I want to know whether Eurotunnel...
Point of order, Sir Peter Bottomley.
Is it customary for a member who is speaking to provoke a minister into looking at her directly and then to say that somehow he's interrupting her? It seems to me far better if the honourable member could go on addressing the chair and leave the minister to listen, like the rest of us can.
Well, the right honourable gentleman has his own interpretation of the chronology of events, which those attending to observe our proceedings can make a judgment about for themselves. That is one point of view. If I may say so, there is another point of view, which is that the honourable and learned lady was somewhat disquieted, not to say mildly irritated, by the evident fascination of the junior minister with the contents of his electronic device, and it might be thought courteous not to be focusing intently on said contents when a member is addressing the House. I hope the right honourable gentleman won't take offence when I say that he is, in the end, ultimately, a very loyal sort of person, and it's not terribly surprising that he should spring to the defence of his ministerial colleague and fellow parliamentarian. Very gracious of him, and a nice try. Joanna Cherry.
Mr Speaker, but I'm not going to leave this one alone. So I want to know how much of that £33 million will be repaid in the event of there being a deal. And I think I know the answer. It will be nil. And I want to know whether there was any legal agreement that any amount of that £33 million was to be spent on improved security, and if so, to what extent. And I won't be leaving those issues alone, either today or in the future. Because, Mr Speaker, I was the first person to raise this issue, to my knowledge, on the floor of the House or in committee earlier this year. when I got hold of a copy of the contract, which is readily available on the internet, the contract with Seaborne Freight, and also, like any lawyer worth their salt, looked up the public contracts regulations and realised that it looked very much like the government had avoided the competitive tendering process which they are bound to carry out under law. And that's why I raised with the Secretary of State for exiting the European Union this issue on the Chamber, in the Chamber on the 7th of January. And I'm going to go through the chronology, Mr Speaker, because the point I want to make is that I've raised this at least half a dozen times, the question of what was the urgent or unforeseeable event that justified this not being a competitive tender. And on no occasion have I ever received the answer which has been given today by the Secretary of State for Transport, that it was to do with a decision taken collectively by the government last autumn to improve the supply of medicines in the event of a no-deal Brexit. The very first time I ever heard that explanation was on the television at the weekend when the Secretary of State for Health used it. Then, of course, he used it again yesterday. But it is very odd, Mr Speaker, and again informs my puzzlement and frustration earlier this afternoon that we've never heard that explanation before. Let me just go through the chronology. On the 7th of January in this chamber, I asked the Secretary of State for exiting the European Union why the contract with Seaborne Freight had proceeded under the negotiation procurement procedure without prior publication, that is to say, not competitively, because it seems to me that it must have been foreseeable for quite a long time that there might be a no-deal situation, and therefore it was hard to say that no deal had come out of the blue and was urgent or unforeseeable. And I received the usual non-answer from the Secretary of State. I won't bore the Chamber with the contents of the answer, they can be looked up in Hansard, but there's nothing about a requirement to prepare for the urgent supply of medicine, and indeed no kind of an explanation at all. The following day, on the 8th of January, I raised the same point with the Secretary of State for Transport on the floor of the House and said I was concerned about the legality of the procurement process, that I had a copy of the contract notice, that, as my honourable friend, the member for Kilmarnock and Loudon, had reminded the House earlier that day, no deal has always been a possibility, because the Prime Minister said right at the beginning, no deal's better than a bad deal. And I asked him what was the reason, what was the urgency here, and had they set aside any funds in the event of legal action. And I got a non-answer, other than to say it was a matter of extreme urgency and no reference to the supply of medicine. So the following day, on the 9th of January, I raised the matter in some detail with the Under-Secretary of State for exiting the European Union at a question and answer session before the Exiting the European Union Select Committee. And I'm proud to say that the segment where I questioned him went viral on the internet, Mr Speaker, because I asked him a number of times to tell the committee what was the urgent and unforeseeable event that justified these contracts not going out to competitive tender, and he was unable to tell me. Now, one would imagine, Mr Speaker, if the explanation that it had been a collective decision by the UK government to put these contracts out non-competitively to deal with securing, in order to deal with securing the supply of medicines, I would have expected the Minister in charge of no-deal planning at the Department for Exiting the European Union to know that. And the fact that he didn't know it and didn't, under sustained questioning, mention it does raise a suspicion in my mind that it's an explanation that has been invented after the fact, rather than an explanation that has always been the case. I'm just going to finish the chronology, then I'll give way. That was on the 9th of January, and then later on I put in some written questions, Mr Speaker, to try and ask the Secretary of State for Transport what unforeseeable events led to his department awarding contracts for additional shipping freight capacity under Regulation 32 of the Public Contracts Regulations. And the reply I received was that a negotiated procurement procedure without prior publication had been concluded to ensure that capacity could be put in place for a no-deal exit whilst, and I quote, at the same time securing value for money for the taxpayer. So no mention of the need to secure the urgent supply of medicines in the event of no deal, but a mention of value for money for taxpayers. Do the government still think they've given value for money for taxpayers, given what we've heard this afternoon? I very much doubt it. Then on the 31st of January, I asked the Attorney-General about this matter, and I asked him, if he was concerned that the government could face legal action in respect of their failure to put these contracts out to competitive tender, if he'd been asked to advise on the matter and whether any money had been put aside for the contingency of such court action. And he fell back on his law officers' convention not to answer that question. But he certainly didn't mention that the reason that these contracts had been awarded as a matter of urgency and non-competitively was because of the need to secure the supply of medicines. Then again, on the 11th of February, I raised this matter with the Secretary of State for Transport, and I asked him, would he state clearly for the record, as I'd asked this question of him and other ministers 5 times now, what were the reasons of extreme urgency and unforeseeable events that justified his department proceeding without competitive tendering? And he said it was a change to assumptions on the levels and length of disruption that might arise in a no-deal Brexit scenario. So perhaps the junior minister could take a note that I want to know from the Secretary of State for Transport why he said on the 11th of February that the explanation was a change to the assumptions on the levels and length of disruption that might arise, and why he's now saying that it was a decision back in autumn to secure the supply of medicines in the event of no deal. Finally, Mr Speaker, I raised the point... I'm just going to finish the chronology and I'll give way. Finally, Mr Speaker, I raised the point again on the 14th of February with the Secretary of State for Transport, asking him what he meant by a change in assumptions. Would he care to elaborate on exactly what he meant by that? And did he think that that defence would stand up in court? Those were my exact words. And he said, and I quote, "I recall explaining on Monday precisely what the circumstances were, and I don't want to detain the House any longer by repeating an answer that I gave to the Honourable and Learned Lady 3 days ago." So again, he had an opportunity to say that the explanation was a requirement to secure the urgent supply of medicines in the event of a no-deal Brexit, but he didn't, and in fact he told me that he'd already told me precisely what the circumstances were 2 days before, when he referred to a change in assumptions and nothing about medicine. So I'm going to give way to the honourable gentleman in a moment. But the point I make is that this is just an example of the number of times that I've pursued this question. I know other honourable members have pursued it, particularly my honourable friend for Kilmarnock and Loudon, and my honourable friend for Glasgow North West, and others have pursued in some detail their concerns about the supply of medicines after a no-deal Brexit, and never has it been said to them, don't worry, we're so concerned about this as well that we've risked breaking the law on competitive tendering to sort it all out. So that's why, Mr Speaker, I am highly sceptical. Now I give way to the honourable gentleman.
Learned lady for giving way. I've been listening carefully to her submissions this afternoon, and this issue about what the purpose was for was dealt with in the NAO report. It said it was to ensure prioritise the flow of critical goods into the UK. And specifically it says in September and October 2018, the intention was to ensure the capacity and flexibility exists for the government to prioritise the flow of certain goods. In November 2018, the business case of the department was to ensure the capacity and flexibility exists for the government to enable the prioritisation of certain goods. It seems to me that critical goods was always in the mind of the department, so I'm not sure her submissions to this House really bears out.
I'm very grateful to the honourable gentleman for making that point, because he actually reinforces the point that I sought to make. So the National Audit Office appear to have that information. The House of Commons has it today and yesterday. But my point is that on repeated occasions, when I asked a number of ministers from different departments what the explanation was for this urgent need to tender non-competitively, not on one occasion did any of them mention what we are told was a collective decision to do it for a particular purpose. And therefore, I question whether this explanation has not been invented after the fact, and I give way to the honourable gentleman.
I'm very grateful to a lady for giving way. I mean, she's doing a brilliant job of exposing the facade that's been put up to excuse this reprehensible behaviour. But isn't the bottom line is that the government knew that they were in breach of their own procurement rules and that Eurotunnel were going to win, and that is why they settled the case?
It is the bottom line. The honourable gentleman is absolutely right. And I'm going to draw to a conclusion now, because I know other people want to speak. But what I would say, Mr Speaker, is that the history of this whole event on the part of the government and what they say they all knew about because it was a collective decision now has been one of evasion and obfuscation. And I and others am left with the inevitable conclusion that what they are doing is trying to cover up a monumental error of staggering negligence in their preparations for a no-deal Brexit, which is costing the British taxpayer a lot of money. And I'd like to point out that Scottish taxpayers didn't even vote for all this nonsense in the first place, and their representatives in this House have done their best, apart from the Scottish Tories, to try and get a no-deal Brexit off the table. Now, I came to this House this afternoon planning to ask for the resignation of the Secretary of State for Transport. That's been asked for by others already. But now that we know that this is a collective decision and they're taking collective responsibility, what I would just like to say before I sit down, Mr Speaker, is that in any normal, healthy, functioning democracy, this scandal would bring the government down.